So yes, I was asked to talk about the last evolutions of the French legal framework, which is obviously based on the European legal framework. So I'm going to talk a little bit about the context at the beginning. You all know that, but it's just to explain how we got to the discussion in France. So Article 1 of the directives, most of the directives, says that the directive apply to the production with a view to marketing and to marketing of plant propagating material. And Article 2 then defines what is marketing. And marketing is the sale, offer for sale, transfer, with a view to commercial exploitation. Actually, in English, it says aimed at commercial exploitation of seed to third parties, whether or not for money. So we wanted to exploit that definition in the sense that was done by Denmark, and exploit especially that expression, aimed at commercial exploitation, right? So there was a discussion, a controversy about that expression. What does that really mean, aimed at commercial exploitation? We had a long discussion with the ministry about the comma missing here. The first time I had such a long conversation about a comma, and they were saying that the comma is missing, and that means that aimed at commercial exploitation only in the English version means that only the transfer is aimed at commercial exploitation, but the sale is the same, right? But in the French version, there is a comma. In the Spanish version, there is a comma. In the German version, there is a comma. And they were saying, yes, but the English version is the official version. And I was saying, no, all the versions, the different versions are official versions. And with the Brexit, the English version is going to be the non-official version. And then here it's the end of the article. It's even clearer when you look at the second paragraph of the Article 2. It says, trade in seed not aimed at commercial exploitation of the variety shall not be regarded as marketing. So the part that is underlined is very clear. And then you have an enumeration of situations where there is no commercial exploitation of the variety. So you have supply of seed to official testing and inspection bodies, and you have also supplies to providers of seed for processing and packaging, the closed loops. Okay, and so then you have the administration saying, well, but only these two situations are situations where there is no commercial exploitation. And we would say, but such as, here, such as is the indication that this list of situation is not limitative. These are two examples, but these are examples. And we're saying, no, they're not examples. And then we took the German version, and the German version is so clear because it uses that expression, wie zum Beispiel. That means it's a shorter way to write that, and wie zum Beispiel means like for example. So this is very clear that this list is just a list of two examples. And then we also took the Danish example, which is this. We called it a circular. We don't even know if it's a circular or just a guideline, but it's a guideline for the administration, right? A circular.
It's a legal document.
It's a legal document, yeah. Then it's a circular. And paragraph 7, this is the Danish version, I don't understand it, but it's in the paragraph 7, it's very clearly stated that when it's not aimed at commercial exploitation, then it's not marketing, and then that means that the directive do not apply to the transaction, and then you have a list of examples. Here is the paragraph 7, and here it's the translation of the paragraph 7. And so we use that. We use that in the Danish version, and then we had the English version also transferred to the ministry, and also the deputies and the Senate. I'm gonna explain. And also we had a French version. We had a person in Denmark translating the text into French. And then we were communicated that document too, that we also sent over to the French civil servant. And this is very clear. It's one of the slides. You presented it before. Private use, hobby gardeners is not considered are not considered making a commercial exploitation of the sea. So the idea, because it's the only margin of maneuver that we have at the national level right now, is to liberalize the sale of seeds to non-commercial end users or home gardeners, if you wish. So we wanted to exploit that within the framework of the Biodiversity Act, or the Biodiversity Bill at the beginning. That was under discussion in France during almost 2 years. So that's a simple scheme of the French institution, just to show you that the government issues a bill, as it is in many countries actually, issues a bill, and then it goes to the Assembly of Deputies or to the Senate. They choose which chamber they choose first. And then there's a navette system, as we call it. So the text needs to circulate between the two assemblies. And when the text is voted in the same terms by the two assemblies, then the discussion is not, the article or the provisions are not under discussions anymore. The text is definitive, and then the act can be adopted. Okay, so that was the process and the long adventure. So the bill steps are as follows. The bill was issued in 2014, and the procedure was very, very long, because we have a National Assembly that has a left-wing majority and a Senate that is a right-wing majority, and they could not find an agreement. And so the final reading took place on July 2016. So I'm going to show you the different version of the Article 4, because the amendment was introduced in Article 4, and then you will see the different versions. So Article 4, at the beginning, this is in French. Article 4, this one, was introduced by a small association with very good will. That I was contacted by them, but they wanted to forbid hybrids on the market. That was the original idea, and it's absolutely not realistic. But they managed to have that voted by the Senate, and so they introduced these words here in the Intellectual Property Code, so that only seeds that would be reproducible in a natural environment would be able to get a plant breeder's right. And it made not much sense, so that was dropped after first reading in the Senate. And then it came to the National Assembly for the second reading, and there we transformed that amendment into something that would allow the transfer of seeds to non-professional end users without having to register the varieties in the catalogue. And so the first drafting was pretty good, because we had offer for sale and transfer and supply, and any transfer, supply, or transfer again free of charge or onerous. It's a translation of French, of seed or propagating material of plants to non-commercial end users not aiming to make a commercial exploitation of the variety are not subject to prior authorization. And that was put in the environmental code. And then it went to the Senate on May 2016, and the opposition was very strong in the Senate because the senators that were there were clearly representing, especially one person that is very well known for that in France, was representing the seed industry interest. And so they, also with the agreement of the Ministry of Agriculture, opposed these amendments and modified it so that only the transfer, the transfer supply free of charge would be allowed. That meant that the text wouldn't have any commercial stake at all, right? And the Ministry of Agriculture was agreeing with that position, and so that was pretty much a deception. And so we went, you see, free of charge. And so I went again to the deputies in the National Assembly, and for a new reading, and we found an agreement, also with some representative of the right wing, where we had another wording allowing exchanges free of charge, but also against money when these exchanges against money would be done by non-profit associations. And also, you see, if carried out by an association governed by the French law on the contract of association for consideration, that means for money. And also only if the varieties would belong to the public domain. And the Ministry of Agriculture absolutely wanted the sanitary health rules to apply. So we added that, and that was the compromise. And that compromise was voted by the National Assembly, and then it was voted by the Senate on July of this year. And so, as it was voted in the same terms by the two chambers, it was definitive, it was conform, definitive, and not under discussion anymore. So that law, that Biodiversity Act, was adopted in July 2016. To achieve that, you don't imagine. That was a lot of efforts. Kokopelli made movies about that, interviews that were circulating on Facebook, and mailing campaigns. And then Pierre Rabhi also intervened. I don't know if you know him, but he's a very popular philosopher in France, talking about the Biodiversity Act, Facebook and mailing campaign again, and thousands of meetings and telephone calls and emails. Many persons, many politicians, and this is only a short list of persons that we had to meet to get to that result. And then, so that's finally that Article 4 was transformed into the adopted law into Article 11. And then, after the adoption, there is one ultimate recourse that is on the hands of the deputies and the senators, and also on the hands of the minister, the prime minister, is to have recourse to the Constitutional Council. Sorry, I have to explain that. And that's what happened. After the law was adopted, and that Article 4 was transformed into Article 11, we had 60 senators and 60 deputies signing together a recourse to the Constitutional Council, saying that, criticizing only 4 articles in a very long act, in a very long law, and considering several principles that are enshrined in the constitutions. And among these 4 articles that were criticized by the right wing, Article 11 was there. And the only article that was censored by the Constitutional Council was Article 11, if you can believe it. So we had the government defending the text that was voted by the 2 assemblies before the Constitutional Council, but with not a lot of motivation actually, and weird arguments. They were saying basically, well, this compromise that you have in this law is okay because it's not destabilizing the seed market. So that was the intention behind. We're not really taking the full. We're not taking all we can out of the European legislation and applying the rule of law as it should be. We're only imagining derogations that are not destabilizing the market. And the decision of the Constitutional Council was as I said, it censored the text on these grounds. The Constitutional Council in August said, finally, associations are not placed in a different position from other legal or natural persons, and the difference of treatment that is established in the Article 11 then disregards the principle of equality before the law and is contrary to the Constitution. And so we had the text with a series of words that were erased by the Constitutional Council. All the words that made a reference to these non-profit associations were censored, but also these 2 words with no real reason actually, because the Constitutional Council that says, well, there's a disruption in equality could have said that derogation should benefit to all operators. It's not okay if it's only for non-profit organization, but if it's for every operator, it can be accepted actually, and it can be left in the text. It's free of charge or it's against consideration. But it erased also against payment, and now we have that text in the rural code. So Article 11, it's that text. So now there is a derogation, but it's not a very good one because it only allows the exchange and the transfer free of charge of seeds that are not registered in the catalogue when the variety belong to the public domain to non-professional end users. That's what we have right now in the rural code. So what I've learned from that process is obviously that the Ministry of Agriculture in France is very reluctant. We had strong support from the Ministry of Environment, the Ministry of Ecology, but the Ministry of Agriculture is very reluctant, is very close institutionally from the seed industry. The GNIS, the structure is so particular in Europe, where you have the seed industry really inserted into the Ministry of Agriculture, and that is it's very difficult to see a change happen because the interests of the seed industry are constantly taken into account by the minister himself, and also that they don't want to let go anything, not a tiny piece of that legislation. And it's also for a reason. I mean, this legislation on the marketing of seeds comes from France, and then it has been copied at the European level. And so the French industry has built itself and its prosperity on the basis of that legislation. So now we have began a dialogue with the Ministry of Agriculture again, trying to convince the cabinet of Stéphane Le Foll. Stéphane Le Foll is going he's arriving at the end of his mandate, so he will not be in charge next year. But civil servants, you know, they remain, and so the dialogue is always a good tool, a good driver for change, as we said before. And we're trying to reintroduce the possibility to transfer these seeds and varieties free of charge and against money in another legislation which is under discussion right now, which is called the Mountain Law. We have only two pieces of legislation that are being discussed in France before the end of the mandate. You know that we're coming to presidential elections right now in France, so until the end of the mandate we have that law and another one. And so maybe we can reach some result before the end of the mandate. And obviously I continue the work at the European level. So that's a sentence from Benjamin Franklin. It's a legislation that has been applying for more than 50 years, and obviously, you know, there's a strong inertia to see things change. But I believe that, you know, with persistence and goodwill and also good collaboration between actors that have the same objectives, we can surely reach a result. When you look at the very history of the creation of that legislation, it was not born from one day to another. It started at the beginning of the 19th century, the 20th century, and it reached the actual situation in the 50s actually, and in the French history. You had different texts, and you can see very clearly the evolution. And the evolution of these texts show that that piece of legislation was put in place to valorize the intellectual property right regime that was put in place just at the same time. And so we have a situation where we have the same criteria for the delivery of IPRs and the same criteria for the registration in the catalogue. And that's full similarity is very problematic, because the catalogue ends up being a tool of promotion of an IPR regime. And then the catalogue is a catalogue of protected varieties. And with that system, where you have the two things that are completely one on top of the other, you push the public domain into illegality. And this is very shocking from the legal point of view. I think it's the most shocking thing for me in the whole legislation. It's that situation where you have the public domain being pushed into illegality, where actually public domain should be the rule, and the protection should be the exception, because we all create innovation on the basis of the public domain. This is really the common pot for innovation. And it's such that in the PRM proposal of the Commission in 2014, the Commission was even proposing that if you would get an IPR, you would get the variety directly into the catalogue. So the total confusion between the two legislation, which is very insane, because you don't see that in any other piece of legislation in other economic sectors. This is the only one. It's like saying you only allow patented manufacture products on the market, and the rest cannot be there. And it's absolutely not the case. I mean, non-protected goods are the rule on the market right now.
So it's really, if we turn from the legal point of view to economic point of view, it's a barrier of entry for few companies that have claimed the whole industry to themselves. And it's may I say the word again, appalling to see this happening, because this is not a Western world. This should not be the case.
No, well, and uniformity. You know, we talk about and we have a very high levels of uniformity that are required. Uniformity is a indispensable precondition for the enforcement of IPRs. We have to understand that. If in a batch of seeds you don't have absolutely identical individuals, then you cannot enforce the plant breeders' right you have on them. So it goes together. We don't need that level of uniformity on the fields. We need that level of uniformity to enforce IPRs. So that's appalling, yes. And I think we need to bring consciousness about that, because it is in the landscape. It has been in the landscape for so long that we think it's natural.
Absolutely.
Yeah, and it is not. And I will. It's not only Machiavellism. Huh? It's not only Machiavellism. It was also motivated by a will stemming from general interests also, because it's true that after the war the intention was to modernize agriculture and increase productivity, and we thought with goodwill at that time that would be the solution for it, and it was done in a very authoritarian manner. At that time the civil society was not as reactive as before, so that was done a little bit like the USSR. It was interventionist and planificatory and authoritarian. And then we remain with that framework, and that is also what the European Court of Justice said. It said at that time the intention of the legislator was to increase productivity. And that objective can justify the strong constraints that were put on the seed market. If I were to re-evaluate the proportionality of these rules today, that would be another story, because we don't have that objective of productivity so high on the priorities. You understand? So now, if we are asked the question, we need to address this question in a very different manner. And if the Commission puts another instrument on the table, then we really need to make a brainstorming and reevaluate all the pros and contras, the alpha and omega of this legislation, and see which are the priorities, and not only just continue with the same framework and the same structure. It's a philosophical questioning that we have to undertake. So I hope this text is going to come back on the table, and we can really ponder upon all together.
We have to be prepared first.
Yes.
Time.
Yes.
This time to look at it from the legal point of view and from the philosophical point of view, and anything that can be used, and not just from the agricultural industry point of view.
Yes, absolutely. Absolutely, yes.
And now we will have coffee break, but just a short comment on that. As Meredith showed to us, the whole legislation is legally based on Article 39 of the treaty, and this mentions increasing productivity, but it also mentions increasing the livelihood of the agricultural community. And if you look at that, then you could prove that using diverse varieties can lead to better income for farmers. So there is a different narrative which could be told if there is a political will.